He is currently a professor of law at Santa Clara University and a contributing editor to Liberty magazine. As many of you already know, David Friedman is the son of economists Rose and Milton Friedman and the father of Patri Friedman, who we heard earlier today. So please join me in welcoming Dr. David Friedman.
You aren't supposed to tell people that Patri's my son. That way I'll get blamed for him as well as for me. All right, what I wanted to talk about tonight is the fact that most modern legal systems, including ours, are redundant. They contain two systems of rules, two mechanisms that do essentially the same work in different ways. The logic of both is the same. You do something bad to somebody, the legal system intervenes, something bad happens to you, that's a reason not to do bad things to people. One of them is called tort law and one of them is called criminal law. And it was a point that was dramatized a few years ago when O.J. Simpson was first acquitted of the crime of killing his wife and then convicted of the tort of killing his wife. The essential difference between the two systems is that criminal law is publicly prosecuted. As you may know, you will never be the victim of a crime in California or in any other state. You may perhaps be an important witness, but any crime that occurs in California, when the case gets to trial, will be in the form of the state of California versus Smith, Smith being the criminal, because legally speaking, it was the state of California and not you that was the victim. You can, however, be the victim of a tort. Right? So in one system, the state takes over the job of prosecuting people who've done bad things. In the other system, the victim controls that process. In criminal law, the state can have an out-of-court settlement. We call it a plea bargain. In tort law, the victim can have an out-of-court settlement. We call it an out-of-court settlement. The prosecution in criminal law is done by an employee of the state. In tort law, by a lawyer, usually hired by the victim. And this raises to me an interesting question, which for some reason law schools don't usually notice or teach their students, which I think anybody interested in the law ought to think about. Do we need both systems? Is there any good reason why we should have both criminal law and tort law? Also, is there any good reason why they differ in the way they do? The outcome of the O.J. Simpson case is not so surprising if you remember that the standard of proof in criminal law is proof beyond a reasonable doubt, whereas the standard of proof in tort law is proof by a preponderance of the evidence. So in principle, if both courts, both juries thought that the chance that O.J. Simpson was guilty was 60%, he ought to have been acquitted of the crime and convicted of the tort, since they have different standards. So those are all, it seems to be, interesting questions. Now one could imagine abolishing either of them. You could imagine a pure tort system, or you could imagine a pure criminal system. And in fact, both historically have existed. My current writing project is a book on legal systems very different from ours, coming out of a seminar I've been teaching at Santa Clara University Law School for some years. Curious people can find the draft of the book up on my webpage, web for comments. But we know one of my favorite legal systems, which I've written and spoken about before, is that of Saga period Iceland. It was set up in 930 A.D. It collapsed in the 1260s, so it lasted for about a third of a millennium. And that was a legal system where if you killed somebody, his relatives sued you. So that was a pure tort system. And it was a purer tort system than our tort system because there was no executive arm of government. So after you won your case, it was up to you to collect. All the court system would do if the defendant did not pay the damages that were adjudged was to outlaw him, at which point it was legal to kill him. He had 2 weeks to leave Iceland, and tortious to defend him. So that was a pure form, pretty pure form in one direction. On the other hand, as best I can tell, the legal system of Imperial China, which lasted with some changes for nearly 2,000 years, seems to have been a pure criminal system. That as far as I can tell, if I lent you money and you didn't pay it back, there was no mechanism to sue you. All I could do was report you to the district magistrate as a swindler. And the district magistrate could say to you, pay him the money and I won't do anything. He could say, pay him half the money, I won't do anything. He could refuse to prosecute. He could say, I don't care if you give him the money or not, we punish swindlers. It was in his control, not yours. Criminal, rather. So the particular version that I want to discuss tonight, as the title of the talk suggests, is abolishing criminal law. I want to ask whether in something more or less like our present society with our present institutions, this is my conservative talk, I'm not proposing abolishing the government tonight, whether in such a system you could abolish criminal law, replace it with some version of tort law, what problems you would face in doing that, and how you might be able to modify tort law to deal with those problems. And then I also want to say a little bit about why, if you could do it, it might be a good thing to do, what the advantages of the pure tort system are. Let me describe briefly the mechanism that I'm imagining for handling the sort of things that are now crimes. That is that we have private firms which function the way a law firm now does, but they're specializing what used to be crimes. So that's going to include detection as well as litigation. The victim has a claim against the criminal. The victim can transfer that claim to the firm that will catch the criminal. The firm can then collect the claim. So what are the problems that would arise in such a system? The first problem that might occur to you is what if the victim is too poor to afford to find the criminal, prosecute him, and collect? And of course, that's already a problem in ordinary tort law. But is there a solution to that? And the answer is there is a solution. The solution was one implemented in Iceland 1,000 years ago. I like to say that we were a mere 1,000 years behind the cutting edge of legal technology. And it is to make tort claims marketable. All right? So in Iceland, the equivalent of being poor was basically not having enough friends who would fight for you. Because if you had nobody who would fight for you, you might get beaten up trying to go to court in order to sue somebody. You wouldn't be able to kill someone who was outlawed and so forth. So if you're an elderly man and your only son has been killed and you want to sue the guy who killed him, you aren't going to be able to pursue that case yourself. But you have a neighbor. And your neighbor has 4 strong sons who went a Viking in their youth, and lots of friends and allies and relatives. So you transfer your claim to him, he sues, he wins a damage payment, he splits that damage payment with you, or if it was a hard job, maybe he keeps all of it, that'll be negotiated between you and him. But the result is that killing your son gets people in trouble, and that's a reason not to kill your son. So that was a mechanism which solved the problem, and it's a mechanism that we can imitate. If you imagine, just think about our ordinary tort system. At present, if your car is smashed and you think it's clear the other person was at fault, you can't afford a lawyer. The closest you can come to selling your claim is to get a lawyer to take the case on a contingency basis. So you can get a lawyer who will say, I won't charge you anything, I'll collect half the damages you will. But you have no good way of knowing which lawyer or which law firm will do the best job for you. Suppose, however, that your claim was marketable. You would just auction it off. Whatever lawyer will pay you the highest price for the right to collect your claim is the one who's doing the best job for you. You are now a witness. You don't need any of your own. So that's one example of something I found interesting in studying these legal systems, the fact you can sometimes get interesting ideas from the way other societies solve their problems. Next problem is the dispersed injury problem. What happens if somebody does something which injures a lot of people a little instead of one person a lot? And each of those people, each of those individual victims doesn't find it in his interest to pursue the case. Well, again, that already exists in tort. We have a mechanism for dealing with that. It's a very clumsy mechanism. It's called a class action. The trouble with it, I don't know how many of you are familiar with it, but the basic mechanism of a class action is you have a case, you have a lawyer who claims there is a case of this sort. He claims a large number of people have each suffered a fairly small injury. He gets a few of those people to choose him as their attorney. He then goes to a judge and asks to have the class certified so that he can represent all of the victims. He then litigates, settles or doesn't settle, something happens. And the trouble with that mechanism, if you think about it, is that it has very little control to get the lawyer to act in the interest of the class. So that what I think of as the typical settlement of a class action is that the defendant, I'm thinking of a firm that's produced a product and the lawyer claims it was in some way defective. So the firm agrees to an out-of-court settlement. They'll pay the lawyer $500,000, and they'll pay the victim $5 million. The $5 million, however, will take the form of discounts on their on future purchases. So they've really paid nothing to the victims. They've paid $500,000 to the lawyers. I've got a better version. I want to not only make tort claims marketable, I want to make inchoate tort claims marketable. I want to make it possible to sell your claim before it's happened. So we can now imagine intermediaries, middlemen, maybe auto insurance companies, medical insurance, anybody, any company that's dealing with lots and lots of people. And they say, look, we'll give you a discount. We'll give you $50 off a year if you agree that any claim of yours for less than $100 will be transferred to us. All right. So you now have a bunch of individual players, one of whom has accumulated 5 million such rights, one 15 million, and so forth. You now have an enterprising lawyer. He thinks he's found what would be a class action case. So he buys it. He goes to the sellers and says, unbundle what you have. I don't want all your claims. I just want the asbestos claims, or whatever else it is. He now is the owner of 100 million claims. He now sues on his own behalf, because since it was transferable, it's now transferred to him. He has an incentive to get as large a real damage payment as he can. The real victims have been compensated in advance for the price at which they sold their claims. Probably not very much, but then small claims aren't worth very much. So this is a way in which you could solve the dispersed injury problem, both for current torts and for current crimes. Now, one of the odd things about the dispersed injury argument is that a form in which is often made by people who are trying to explain why we need criminal law is to say that what looks like an ordinary crime against you really isn't a crime against you at all. It's really a crime not against you or against the state of California, but by everybody in the area. Why? Because when you were mugged, that made all your neighbors scared. And being scared is a cost. That's the argument that's all. And the trouble with that is that that's, insofar as that's a legitimate argument, I'm not sure it is, but insofar as it is, it's an argument for tort law and against criminal law. Because after all, if you are mugged under criminal law, you suffer the mugging, you get no benefit. If you are mugged under tort law, you still suffer the mugging, but now you have a claim which with luck you can sell for some money. All right, so, or pursue yourself if you prefer. That means that the cost of being mugged is less under tort law than under criminal law. If tort law really achieved its nominal purpose, which is to fully compensate the victim, then there would be no cost to being mugged at all after you've been compensated by the law. This is a point which is sometimes demonstrated in a somewhat exaggerated form with a bumper sticker that says, hit me, I need the money. All right. My guess is that very few people really want to be hit, but it is true that for a given amount of damage, you're better off as the victim of a tort than as the victim of a crime, and that means other people have less reason to be afraid of being the victim of a tort than a victim of a crime. All right, there's then another set of problems, which again exist for tort law as well, but you might argue that much of what is now covered by criminal law, they're particularly serious. And that's the problem we refer to in tort law as the judgment-proof defendant. So somebody dents your car, but on investigation you discover he is uninsured and has no significant assets. And if you're a sensible person, you say, well, that's too bad, I'll make my car fixed. It isn't worth, you can't get blood from a stone, it isn't worth trying to sue somebody if there's no chance of it. And in the case of, there are two problems with that. One of them is that you can't collect anything, so you can't punish him. Therefore, he has no reason to drive carefully. And the other is you can't collect anything, so you have no incentive to convict him at all. You have no incentive to sue him. Consider them separately. And let's start with the problem that he's not getting punished. And there are a couple of possible solutions to that, historically. One of them would be to back up your tort law with a criminal option if you don't pay. So you could imagine a system which says, if you are adjudged to owe $5,000 and you don't pay $5,000, then you spend 3 months in prison or something. That's one possible system. That would keep the punishment. And in a sense, that corresponds to the Icelandic system, which is, if you owe damages and don't pay, you get outlawed, and now either you leave Iceland or someone kills you. There's one outlaw in the sagas who lasts for about 17 years. We're not sure if that's historical or not. But typically, it wasn't really practical to stay in Iceland once you've been outlawed. A few people tried. So that's one possibility. Another possibility, another Icelandic solution, is some version of debt slavery. So that in Iceland, they had what they called debt thraldom, which was that one option when you owed somebody and couldn't pay is that you become a temporary slave until you work out. And back when I wrote my original article on Saga period Iceland, I think I sketched out what the equivalent of that might be in a modern society. I was imagining that we have a legal system where your sentence is of the form X years or Y dollars. If you pay Y dollars, fine. If you don't pay Y dollars, you have a further choice. You can go to the government prison and spend X years there. Or you can accept a bid from a private prison that offers to pay off your Y dollars by using you as labor and demonstrates the terms. You know, it's probably going to be more comfortable than the public prison, and it tells you how long you'll have to work there, and hopefully it'll be less than X years. So you could imagine a sort of modern version of debt thraldom along those lines. Now, I should say there's a problem with this solution. I thought it was a really great solution when I came up with it. And years later, I was arguing with somebody online and mentioned this idea. And he said, oh yes, the colonial powers in Africa used that system. When they wanted a road built, they found some excuse to arrest a bunch of people and sentence them to work on the road. And it struck me that it was a real problem, because the difficulty with this system is that now people have an incentive to get other people convicted of things. And if your legal system doesn't work very well, and some people are good at gaming the system or bribing the judges or whatever, in effect, they're expropriating your human capital, so to speak. And it occurred to me that I had heard a much milder version of that story before. I don't know how many of you have read H.L. Mencken, but all of you haven't should. He was a very prominent journalist and essayist in the first half of the 20th century. Brilliant writer, one of the best essayists I know of. He was described by somebody else prominent as the most powerful man in America. This would probably be in the 20s or so, or maybe 30s, probably 20s. Because if you were a sort of up-and-coming young intellectual, you wanted your friends to know that you read Mencken. Brilliant writer. Democracy is the theory that the common people know what they want and deserve to get it, good and hard. Many, many other things. But in any case, Mencken has the following anecdote. He says there was a sheriff somewhere out in some rural area who liked his jail to be in good shape. So once a year, he would send his deputies out with instructions to arrest one plumber, one painter, and one carpenter. And they would spend a couple of, and you know, you with any luck, if they're drawn, you can find some excuse to arrest them. And what happens? They spend a few days in the jail, repainting, fixing up his jail, and then they go. Then he lets them go. And that struck me as a milder version of the same story. There was a much uglier version that turned up quite recently in the news. A town, I think somewhere in Texas, where the police had the pleasant habit of arresting motorists, whether or not they'd done anything wrong, and telling the motorists that if they did not sign a document agreeing to turn over their money and jewelry to the police, they would then have to face the court, might go to jail, their children might be taken off and put into someone else's control if they had children while the process went on, and so forth and so on. And they apparently collected a good many $1 million this way before finally, I guess, somebody objected strongly enough so they got into some trouble. Whether those policemen will ever go to jail, I don't know. I would not bet on it. They did give back a little of the money to somebody. But in any case, it struck me as a real problem. And I, in fact, wrote an article about it. One of my academic articles in the Journal of Political Economy, I think, is called The Inefficiency of Efficient Punishment. Because the point was that forcing people to pay a fine or to work off a fine is a more efficient punishment than imprisonment, because at the same time that they're suffering a cost, somebody else is getting a benefit. On the face of it, it looks like a good thing. In some ways, it is a good thing. That's one reason why fines, in some sense, are better than prison terms, because prison term, the defendant loses, but we don't gain. We got to pay for the prison as well. A fine or a tort judgment, the defendant loses and someone else gains. But it does have a problem. You have to worry about the fact that it then gives an incentive to whoever is on the enforcing side to abuse their power in those sort of ways. That one of my reservations about the economic analysis of law as it's actually developed is that we pay attention to the incentives of criminals and the incentives of victims, but we don't pay enough attention to the incentives of judges and police and legislators, all of whom are part of the system and all of whom want to be treated in the same way as rational, self-interested actors. So that is a problem. May or may not be one you can do. Second problem with the judgment-proof defendant is there's no incentive to prosecute him and to show he committed the crime at all. You would solve that if you worked off the punishment and had to give the money to the victim. You can also solve that by a hybrid system where when somebody is unable to pay his fine, the state imprisons him and pays a bounty to the victim for having brought him in, essentially. That would be a system where the victim then still has an incentive to bring him in. It's worth noting that there's a reason why we are particularly concerned with the judgment-proof defendant in the cases that are now criminal. And that's because many of them are cases where you don't expect to catch anything like all of the offenders. If you think of sort of the typical tort, everybody knows who ran into your car. The argument is only whether it was negligent or not. And similarly for other such cases. Whereas the typical crime, you know someone robbed you, someone stole your car, but it will take some time and effort to figure out who, and you may fail. And that raises two problems for something like a tort system. One of them is it raises the cost of prosecution, because you've got to pay the cost of finding him as well as prosecuting him. And the other is that if you want to end up with an adequate deterrence, you probably need a punishment that is more than the amount he took in order to make up for the chance that he won't end up getting any punishment at all. All right? So that suggests very roughly, and this is not exactly right, and people sufficiently interested in my book Laws Order is webbed on my webpage, as well as available at better bookstores everywhere, which means Amazon. But first approximation, you would like the probability of convicting him times the punishment to be equal to the damage he did. Let's take that as a first approximation rule for criminal punishment. And then as long as the value to him of the crime is less than the cost to the victim, which it normally is, it won't pay him to commit the crime. But the problem is that if you only catch 1 out of 5, that means that when somebody steals a $20,000 car, you have to collect a $100,000 fine, and most criminals can't pay a $100,000 fine. So the more you're dealing with low probability cases, the greater the problem becomes of defendants who can't pay the appropriate fine. And that is the first point in this argument where it looks as though there may be some reason why the things that are now crimes are crimes. All right? Because that problem is particularly serious for the typical crime. So there are a number of possible solutions. One of them I already mentioned, which is to combine it with a bounty system. To say, look, after all, when we abolish the criminal law, we save the government all the cost of having policemen catch criminals. Not to mention all of the cost of having district attorneys prosecute criminals. Great! How about using some of that money to give to those victims who successfully convict somebody and then discover that he can't pay the appropriate fine? So you could imagine a sort of a hybrid system, which is still privately prosecuted, but in which it is the state bounty that makes up for the judgment-proof defendant. But there's one interesting question, by the way, which I will leave you to think about, because it's not an easy question, is why we don't see probability multipliers in tort. Why we don't observe in tort law that in those cases where you don't expect to catch everybody, that you scale up the punishment accordingly. I should say one theory of punitive damages, that's the reason for them, but I don't think it's a very convincing theory. Again, if you're sufficiently interested, I go into that in Law's Order in some detail. There is, however, a different solution. And we now shift from Saga period Iceland to 18th century England, which I have also written an old article about. I should should say the reason I started the seminar that's producing my current book was that I had written these 2 articles. They've been a lot of fun. I learned all sorts of interesting stuff, and I've been lazy for a decade or so. And so I said, how can I make myself do some more work? Aha, I'll invent a seminar for which I have to learn about a whole bunch of other legal systems, because that's what I'm telling the students I'm teaching them. And it worked. It's called a commitment strategy for game theorists and economists. Anyway, let me tell you a little about 18th century England. 18th century England, on paper, had a modern legal system. They had criminal law and tort law just like we do. They didn't, however, have either police or public prosecutors. Right? That's a slight exaggeration. If you robbed the government, there were government lawyers who would prosecute. But the ordinary criminal case, when it got to the court, it was Rex v. so-and-so, King versus so-and-so, just like our California versus so-and-so. Legally speaking, crimes are all crimes against the king. Poor fellow. But as a practical matter, since the king had nobody who he was paying salary to with the job of catching criminals, what actually happened was that any Englishman could prosecute any crime. And in practice, that meant the victim or his agent, just as with tort, prosecuting the crime. And that raises a very interesting puzzle, which was one of the subjects of my article. The article's on my webpage too, by the way, making sense of 18th century criminal law or some title like that. Quite a lot of my stuff's on my webpage. If people want a free education, at least in my ideas, you can get it there. You can also learn about medieval cooking if that interests you. Get a link to my first novel, all sorts of interesting things. Anyway, the webpage, by the way, is www.daviddfriedman.com. It's pretty easy. I needed my middle. If I'd applied about 3 months earlier, I wouldn't have needed the middle initial. Someone would be. Anyway, so 18th century England, the question is, why does anybody prosecute crimes? And there are a couple of reasons, but one reason, I think, is deterrence. That, after all, is why, at the government level, we think it's worth prosecuting crimes, at least one major reason. Only their deterrence is private rather than public. And the easy case is if you are someone who is a likely victim of crime. Suppose you're in the business of dyeing cloth, and you've got lots of valuable cloth spread out in the sun to dry all the time, and you're afraid that comes night, somebody will sneak up and grab some of your cloth and run away. And it happened before, so you want, when somebody does do that, to not only catch him, but make sure he gets hanged, which is the punishment for serious theft, at least in principle. Turns out that, in fact, in the so-called Bloody Code, although all serious crimes were capital, only a fairly small minority of those who committed them actually got hanged. But that would be another interesting story. But in any case, you'd like this guy to be hanged. Why? Because you want the next guy who thinks about stealing your stuff to realize that it's a really bad idea. All right. That's private insurance. And there are versions of that nowadays. I believe it used to be the case, and maybe still is, that the American Automobile Association gives you a sticker you can put on your car which says reward of such and such an amount of money for information leading to getting this car back if it's stolen. All right, that's a case where they are trying to deter people from stealing cars belonging to their customers by threatening to make it easier to get rid of them. So what if you're not a repeat victim? All right, imagine that you're an ordinary Englishman who maybe will be the victim of a felony every couple of years. You're not going to establish a reputation. All right, the second criminal will never refer to what happened to the first criminal. They have a solution to this problem. What you want, again, think of it as a game theorist or as an economist. What you want is a commitment mechanism. Before you are robbed, you would like to set things up so that if you are robbed, you'll prosecute the robber. Because if you do that and the potential robbers know it, odds are they won't rob you. Once you've been robbed, though, it's your incentive to default on your own commitment, because you're not going to get anything out of prosecuting him. It's not like a tort system. All you're going to do is get him, if you're lucky, hanged, and it'll cost you time and trouble and money in order to convict him. So how do you solve the problem? The solution was to create what they referred to as a society for the prosecution of felons. And there were thousands of these created in the 18th century. Typically, each of them was for one town. And it was a bunch of citizens of that town, probably the better off ones, one suspects, each of whom chipped in an annual fee to the society for a sum of money that was then available to pay the costs of prosecuting anybody who committed a felony against them. Now, so far it sounds like insurance, but it isn't insurance, because the final step is to publish the list of members of the association in the newspaper for the felons to read. All right? So it is an ingenious way of pre-committing to prosecute and making sure that the potential criminals have a way of knowing who is or isn't pre-committed. So that suggests another possible solution to the judgment-proof problem, which is, suppose we have a system where when the defendant is convicted and can't pay the damages, something bad happens to him. We turn him over to the state, they lock him up or hang him or beat him with a wet noodle or whatever that system's punishments are. Suppose instead of having a bounty, we have the firms that buy the claims may, if they wish, buy the claim at a negative price. What does that mean? It means you pay the firm, just like my prosecution association, to agree that if somebody robs you, they will make certain efforts to catch you. They can't guarantee to catch everything. In exchange, you get a sticker to put on your door which says customer of Sure Death Incorporated. All right. That's the equivalent of the newspaper list in the newspaper. So that's a way in which you are turning deterrence from a public good into a private good. And if deterrence is worth having, if having criminal law makes any sense, then potential victims ought to be willing to pay enough to have crimes against them deterred so that it will cover the cost of catching and punishing criminals. So that's sort of my next solution. And that really leaves us, as far as I can tell, with only one hole in my system. Only one category of criminal for which I don't really have a good solution. And that's what I think of as an anonymous victim negative price offense. If you imagine a criminal who for some reason doesn't know the identity of the victim. All right? If you rob somebody's house, you can see the notice on his door. If you mug someone in the street, well, maybe he's got a lapel pin that says that he's customer Sure Death. I'm not sure. But you could certainly imagine crimes where you don't know enough about the victim in advance to be deterred, in which case he doesn't have an incentive to arrange to pre-commit to punishment. And so those crimes that are both negative price crimes, meaning that what you can get out of the criminal isn't enough to pay the cost of catching him, and therefore if you sold the right to catch him, you'd have to sell it at a negative price. You'd have to pay the enforcers to agree to catch him. If it's both that and anonymous victim, then I think you have a problem with it. And in fact, one can interpret some of what happened in England in the 18th century as involving that problem. Because in the mid-18th century, they thought they had a problem with a few crimes, and one of them was highway robbery. And you can see that highway robbery is going to fit this pattern. You don't know who's in that coach. And they tried to solve it by setting up very large rewards, a bounty system, for catching highway robbers. And the problem was that this was also an incentive to find some Irishman fresh off the boat who didn't know from nothing and say, hey, Patty, I got this scheme. Let's you and me rob a stagecoach. And then you make sure that a couple of your friends are in the stagecoach or something, are witnesses who are willing to tell your side of the story, and you collect the bounty on Patty. And it looked as though there were a number of scandals where it was pretty clear that either the person who collected the bounty was the one who had arranged the crime, or else the crime had never occurred, it was just a fake. It was being framed, and they eventually abandoned the system. And this reminded me of something else I had read. If any of you would like a vivid first-hand picture of 18th century Europe, let me recommend to you Casanova's memoirs. Right? Casanova was a real man. He was a very interesting man. He feuded with Voltaire. He met with various famous people, including a number of sovereigns. He wrote stuff. There's even some evidence he may have contributed to the libretto of one of Mozart's operas. We think of him mainly as a seducer, but that's really not a very fair description. He certainly had lots of love affairs. He treated his lovers quite well. Some of them remained friends and correspondents for decades afterwards. You can see why he was a successful seducer, because when you read him, he seduces you. You like him. He's an interesting guy. He's a nice guy. But he spent some time in London. And he mentions when he was in London that there was a sign he saw in some windows. I don't remember he said what it actually said. He didn't speak English. But it was the same sign in different windows, and he asked some of his English friends what this sign meant. And he said, oh, that means perjured testimony for sale here. All right, you can see that in a system where there are rewards for convicting people, there are also rewards for perjury. All right, so a lot of that suggests what seems to me a general problem with both existing criminal and existing tort and my proposal, and that is how you try to control fraudulent prosecutions of various sorts. And it's especially a problem for the low probability offenses, because those are the ones where being a victim and successfully catching the guy is profitable, because the punishment is a multiple of the damage done. And I like to imagine even in our present system, without my modifications, it's a dark night, somebody shoves a car into the road in front of a car that's coming down, having 5 of his friends planted along the way who will lie for him. If we had probability multipliers in Tort Law, his $5,000 car is wrecked, he's got lots of evidence to show who did it, they're going to claim, of course, that it wasn't his fault, it was the other guy's fault, and he collects $25,000 because we're scaling it up by 5, because hit and run accidents will be low probability. So that's a problem you're going to have to worry about in any of these systems. I can talk more about that problem let me mention a couple of other things before I go on. One of the problems in any legal system is how you make it in people's interest to convict guilty people instead of innocent. And we try to do that with various rules of evidence. But subject to those rules, we don't do it. If you think about the actual incentives for police and prosecutors in our system, in general, they are better off convicting someone than not convicting him whether or not he's guilty. All right? That police get a record which shows, how many cases they've cleared. Prosecutors, there's at least one case of this assistant prosecutor whose bonus depended on making at least 7 cases. I think it was 7 cases, and convicting at least 70% of them. We have very poor mechanisms, as far as I can tell, for disciplining the enforcers. And there are a couple of interesting possibilities. First, if your incentive is private deterrence, that is the only mechanism I know of where you have, as it were, a selfish incentive to get the right guy. Because almost certainly the criminals are well informed. And if, when the cloth is stolen from your warehouse, you grab the first homeless guy who goes past the door and get him and railroad him into to be hanged, it's not going to do any good, because the guy who really stole the money will come back, stole the cloth will come back next week. He knows he didn't get the right guy, and his friends know. Probably everybody knows. All right. So if what you're trying to do is deter crimes, and if we assume that potential criminals are well informed, it matters whether you get the right guy. So that's one attractive feature of that particular incentive that struck me. Now, the other thing you can do to limit some of this is to have penalties for failed prosecution. I was just discussing this a few days ago. One of my colleagues was talking about patent suits and the problem, basically, of people who sue and they don't really have a very good case, but it's costly to defend it, so somebody settles out of court for some fraction of the amount asked. And it occurred to me that both the Romans and the Athenians had solutions to this problem. Athenian law, this is Periclean Athens, the famous golden age of Athens. Criminal law was almost entirely privately prosecuted. But the reason it was privately prosecuted was that most of the crimes, the punishment was a fine, and for most kinds of crimes, the prosecutor got a large share of the fine, sometimes more than half of a particular crime. So there was obviously an incentive to prosecute people, but maybe too much incentive, because it's a system with lots of room for demagoguery, big juries. So you could imagine that you look for somebody who's got a good deal of money and isn't very popular, and you accuse him of something. The Athenians were not stupid. I like to describe the Athenian legal system as the legal system of a mad economist. It's sometimes more logical than it ought to be, as it were, but it's clever. And one of the features of that system was that with big juries, if the prosecutor the private prosecutor in a criminal case did not get at least 20% of the jurors to vote for conviction, he was fined 1,000 drachma, which was about 2 years' wages for an ordinary working man. So it's a non-trivial sum. Not huge if you're rich, but it's a non-trivial sum. So that was sort of a neat idea. And in Roman law, in the original Roman system, when you started a case, both plaintiff and defendant had to deposit a sum of money with the court. And the winner got his money back and the loser didn't. I think it's the case, but I have to check this more carefully. Well, I don't like to check it the Roman because I've got an ambiguous source, but I think it's in the case of the Athenian as well, that in some tort cases, if you failed to win the case, and I'm not sure, I think in the Athenian, I was looking briefly because I wanted to check this for something, and I didn't find it, so let me qualify this is by memory. But I think the answer is that if you fail in a tort case, which are also privately prosecuted, of course, and we don't know whether failing means you don't get a conviction or whether failing means fewer than 20%. You owe the defendant a sum of money which is a proportion of the amount you claim he owed you. And similarly, in some categories of Roman law, if you failed to get a conviction, you owed a fine of, I believe, 30% of the amount you had claimed, and it isn't clear from my source whether that was going to the defendant or going to the state. But there are various systems which attempt to restrict abusive prosecution by saying, if you sue somebody and he's innocent, you've imposed costs on him, you ought to pay some kind of damages. And that's a possibility. All right. So far, I've been trying to persuade you that with a few difficulties, a pure tort system would be workable in a modern society. You'd want to modify things a little bit. Then the question is, why bother? What are its advantages? And of course, the first advantage is the general advantage of privatizing anything. Governments aren't very good at doing stuff. They're not very good at making cars. They're not very good at growing food. They're not very good at catching even would-be criminals either. So that would be one argument. But there's, I think, a maybe more important problem, which comes out of the fact that criminal law is controlled by the state. That in a criminal trial, the judge and the prosecutor are both being paid by the same people. They're both state employees, even though the mechanisms are a little different. In a majority of all felony cases in the U.S. at present, I believe, the defense attorney is being paid by the same people too. Because in U.S. law, an indigent felony defendant is entitled to state-provided defense, but he's not entitled to choose his lawyer. All right? There are several different mechanisms. There are some places where there is a public defender whose job is to defend the indigent defendants. There are some where the judge appoints a lawyer and he's paid some amount of money to do it. But there are all systems in which, and I think a majority of all felony cases in the U.S. I think are indigent defendants. I believe that's still the case. So a majority of all cases, the lawyers for both sides and the judge are all working for the same people. That is not a safe system. That's not an adversarial system. And in practice, it's not an adversarial system. If you look at how it actually works, the state-appointed attorney generally has fairly strong incentives to get cases through and not to make life hard for the DA he's got to work with, or the judge who may or may not have appointed him. Not much incentive to waste time and effort getting his guy off, so that you get a lot of plea bargains, and a lot of those plea bargains reflect the fact that even a defense attorney who actually, in some sense, is an honest man, he has limited resources. So what is he going to do? He can say, well, there are a few cases where I might really have a good chance of winning. I'll fight those, and in order to make it possible for me to fight those, I'll concede the others and get the best deal I can, but it may not be a very good deal. So that's a problem. There's a further problem that comes out of it. When I was looking at the 18th century English case, one of the things I wondered about was why they didn't switch to a modern system of public police and prosecutors. I should say police in England originated about 1830 or so. And they don't actually get public prosecutors till late in the century, although the police are functioning as sort of de facto public prosecutors before. But it wasn't as if a system of police was a new idea. France had a modern system all through the 18th century. They had paid police, they had paid prosecutors. Now, one answer, of course, is the reason the English didn't do it was the French did. But the English did it in Ireland, too. The English rule in Ireland also had essentially paid prosecution enforcement. And one possible answer, if you think about the history of England, as you may know, the 17th century in England was a rather interesting time. They had a civil war that ended when Parliament defeated the king and hanged him. They then had a second civil war that ended when Oliver Cromwell and the New Model Army defeated everybody else. They then had whatever 7 or 8 years of military dictatorship under Oliver Cromwell, who I should say was probably one of the more competent rulers England had. The fact that he's a military dictator doesn't mean he wasn't a good one, but that is what he was, and that's how he got his power, by controlling the army that could beat everybody else. They then had in effect, a coup in which Oliver Cromwell's son was kicked out, and they brought back in the son of the king whose head they cut off. Then, after a while, they got unhappy with that dynasty when I think he dies, and his brother, who is Catholic and more competent, is going to inherit. And so they have another coup called the Glorious Revolution, in which they kick out the Stuarts and bring in the ruler of Holland, who is married to somebody who has some connection to the English royal house, and William and Mary. And then eventually that line runs out and they bring in the Elector of Hampshire, whose descendant was the King George who fought the colonists. So altogether, it may have occurred to them that you might worry about just how much power kings had. And that if the prosecution of crime was controlled by the crown, the king's friends could get away with murder. And that's not only an 18th century worry. It's a worry for us too. I was a graduate student in Chicago when there was a high-profile case of police killing a couple of Black Panthers. And the Panther's story was that the police came to the door of an apartment full of sleeping people at night and opened fire through the walls, killing 2 people. And I commented to a left-wing friend of mine that I was perfectly willing to believe that the Chicago police were lying, but I was also willing to believe the Panthers were lying. I didn't trust either group. And she replied that the Panthers were offering guided tours to the apartment. So I went. And it turns out that when a bullet goes through a wall, you can tell which direction it's going by the splinters. And it was all income, every single hole. And eventually, the district attorney who was in charge of the raid got charged with obstruction of justice and acquitted. None of the policemen were ever charged with first-degree murder, which I think is what they were guilty of. Maybe manslaughter if they thought somebody was shooting at them or something. However, the city, county, and I think state settled, if I remember correctly, for a couple $100,000 in damages, the tort suit raised by the survivors of the raid. And that suggested that one real advantage of tort is that while it's still a government court, it's a lot harder to dismiss something once it's in court rather than before it ever comes into court, and therefore having criminal law controlled by the state was a dangerous situation. It made governments dangerous. And there have been a variety of cases since then. There was the Steve Jackson case when the Secret Service seized all copies of a book to be published in blatant violation of federal law. The fact was pointed out to them the day after, and 3 months later they gave them back. 4 months, something like that. Steve, no Secret Service agents were ever charged with any crime, but Steve sued in a Texas court and won damages from the Secret Service. Not nearly as large damages as he should have, but he won them nonetheless. There was the Ruby Ridge case that some of you may have followed, where basically the law enforcement people got somebody to cut down a shotgun an inch shorter than the legal limit, tried to use that to blackmail him into being a spy for them on other members of whatever anti-government movement he was a part of. When he refused and went into the wilderness, essentially, they came after him and ended up killing, if I remember correctly, his son and I think his wife holding a baby. And that one, again, I believe he collected damages. I think one of the FBI agents did get charged in state, not federal court. They eventually dropped the charges, but I'm pretty sure he collected damages from the offenders. So all of those cases, and of course, as you probably know, our previous president was a confessed felon. There is a law called the Foreign Intelligence Surveillance Act, FISA. FISA restricts ways in which the government can intercept communications between people outside and inside the U.S. It says they can only do that with the approval of a special court, which at least at the time it was said it never turned down a request. It turns out that they were, in fact, intercepting extensively without that approval. Furthermore, it turns out that Bush reported information from those interceptions knowing that was how it was done. And the FISA statute says that either intercepting it or knowingly using information from this interception is a felony with, I think, a penalty of $10,000 or 5 years. A further bit, which again, for the real enthusiasts, what first got me into some of these issues, and it first got me really into using economics on law to a large extent, was an exchange between two very prominent economists and two very prominent law and econ people, all of them at the University of Chicago. Gary Becker and George Stigler wrote an article on the compensation of enforcers, in which they argued that there was a problem with the standard model of law enforcement, and that was that in the language of economics, it was not incentive compatible. I'm a cop, you're a criminal. I got the goods on you. Being caught and convicted is the equivalent to you of a $100,000 fine. Getting you caught and convicted is a gold star on my report card and will raise my lifetime income by $10,000. From the standpoint of Dragnet, it's perfectly clear. I turn the evidence over to the prosecutor, you go to jail. From the standpoint of economics, it's perfectly clear. I have an asset that's worth $10,000 to me and $100,000 to you, and markets move assets to their highest value use. You pay me something between $10,000 and $100,000, and I burn the evidence. Therefore, Becker and Stigler argued, in order to have that system work, you need a second layer of cops watching the first layer. Well, they said there's a very simple solution to that. How about instead of paying cops a salary, when we bring the guy in and give him a $100,000 punishment, the $100,000 goes to the cop who brought him in? All right. It didn't occur to them they were reinventing tort law. And of course, they weren't quite, because at that stage, they weren't assuming it was the victim who had the right to claim. But they wrote an article along these lines. Judge Posner and Bill Landis, who were two of the central law and econ people in Chicago, wrote a response in which they argued that first they pointed out some of the problems that Becker and Stigler hadn't thought about, that who owns the right to collect the fine and stuff. But they then argued that one could not make a system of that sort as efficient as a perfectly run government system would be. And the reason was that when you set the penalty for the crime, you were setting two different things. You were setting the punishment of the criminal and the incentive to the enforcers to catch him, because that was their reward. Well, in principle, if you knew enough, you could figure out how hard you should try to catch each criminal and what you should do to him when you catch him. And there's no particular reason why the fine that gives you the optimal punishment would be the same as the fine that gave you the optimal incentive to enforce. And it was a very neat argument. I don't think they understood the argument quite as clearly as I've just described it, but they came up with it. And I got interested at this point, and I ended up writing two different articles. One of them was my Icelandic article, because that was a real society that had done it that way. And the other was a purely theoretical article in which I demonstrated that by making a very small change in the institutions that they were setting up, one of the maximizations got done by the profit maximization of the enforcement firm, leaving only one to be done by the court of civil punishment. That was what got me into doing law and econ. I submitted both articles, I think both of them, to a journal or to two journals that the University of Chicago Law School controlled. They published both articles. When I got back the referee's report on one of them, I should say the editor of the journal in question was Bill Landis, and my comments on the Landis and Posner article, the referee had referred to the article as we. So I think I know who my referee was. And Landis and Posner offered to bring me to Chicago as a faculty fellow in law for a year. I was in New Orleans at the time, so I went, and for various reasons ended up being a faculty fellow for about 8 or 9 years there, and then came out to California. So that's basically how I got into that particular business as a result of that. So that's one reason I'm interested in all of these things, because Becker and Stigler, who are people I think highly of, had the idea, didn't think it through well enough, but it seems to me raised a very interesting question that isn't discussed enough, why we have both criminal and tort law is there a good reason, how you would modify tort law to swallow criminal